Welcome to an oral argument session of the Fifth District Court of Appeal. My name is Rand Wallace. I'll be presiding over this case this morning. I have joining me on the panel from Duval County, Judge Harvey J., and from Brevard County, Judge John Harris. And we have one case on the docket this morning at 10. It's Rita Financial LLC versus Dashka Ben Patel. And please just make sure that you have any devices that make noise, that you have those muted so it doesn't interrupt the parties when they're making their presentations. I'm going to assume that the appellant wants to reserve 5 minutes for rebuttal unless I hear differently from you, Mr. Schiavone or Schiavone.
It's Scavone, sir, and yes, 5 minutes for rebuttal, please.
Okay. And so other than that, you are free to proceed. Go ahead, Mr. Scavone.
Thank you, Your Honor. Good morning, and may it please the court. The trial court erred in granting summary judgment in favor of the appellee, Daksha Patel, because record evidence establishes the existence of genuine factual disputes. As you will hear, the material facts are not so one-sided such that Daksha should prevail as a matter of law. On this record, a reasonable jury could find in favor of Reedy. After accepting an $850,000 loan from Reedy to purchase the Lantern Motel, the appellee conveyed the motel to herself for $100 and then sold it for $1.2 million. Despite this windfall and her repeated promises to pay her debt, the appellee walked away from her obligations without paying a penny.
Mr. Scavone, I have an initial question about the oral contract. You would agree with me that the components of that would be an offer, an acceptance, consideration, and sufficient specification of the essential terms?
Yes, Your Honor.
What were the essential terms as to the oral contract between your client and Miss Edwards' client?
So the initial precise terms, Judge, in 2004 was that Reedy would loan Daksha and her late husband, Raju, $850,000, and that they would repay that when they sold their home in New Jersey. That then, over a course of a series of promises, turned into the loan will be repaid when the Lantern Motel was sold. So that is the promise that was made by Daksha.
Well, let's rewind back to 2004. According to Daksha, she says there was no agreement. She was not privy to the agreement. And I understand as to a summary judgment process that may or may not matter. But then I see your client who, and this is page 435 of the record, who says he doesn't know whether she understood the oral agreement or that she would be part of it. And I just quote from him, I cannot say yes or no, but we talking, those were his words, our Indian language, and I think she understand. How could that be a specification of the essential terms if your client says, I don't know whether she understood or not?
Well, Judge, I think there are a couple of things there. First of all, there's no question that Daksha and Raju were present with Bharat and Trupti.
And I see that,
Yeah.
Mr. Scavone. They were both there. They were eating dinner, I believe, at their house, correct?
That's correct. At Daksha.
So I fully understand that. But,
Yes,
but
sir.
how do you get around your client saying, I don't know if she understood or not, and Daksha saying there was no agreement?
Well, Judge, I mean, there's also testimony from Bharat. He testified in his deposition that at that dinner, both Daksha and Raju asked for the loan. That's at record 666. There are sworn affidavits from both Bharat on behalf of Reedy and Trupti, his wife, attesting to the fact that they had this discussion and that everyone there understood that there was a loan being made from Reedy to Daksha and Raju. And I think at this stage, Judge, considering this is summary judgment, despite the fact that Bharat may have said he doesn't know whether or not Daksha understood, there are certainly inferences, reasonable inferences, that can be drawn that someone who is sitting at the table with the loan, with the lender, and having a conversation and saying, and that conversation, as is supported by the record, was about this loan, when it would be paid back, and how much. I think that's certainly enough to overcome summary judgment.
Well, and it may be that there would be inferences, but I've got testimony for your client saying I can't say whether or not she assented to those terms. Doesn't that win the day?
No, I wouldn't say so, Judge. I mean, he's saying he doesn't know. He can't know what is in what Daksha is comprehending or what's in her mind, but he can know that she's there when the loan is negotiated, and he's attested to that, as his wife did. And there's more inferences that can be drawn, Judge. For example, Vish Mangal, the accountant for Ms. Patel, testified in his deposition that when he was asked whether or not Bharat loaned any money to her and her late husband, and the accountant said that he, in fact, when the exact question was, at any time did Bharat call you and tell you about the loan? And Vishmangal's response to that was yes, that he had in fact talked to Daksha, and that Daksha told him that she wanted to, quote, give money to Bharat for the loan that had been made to her and her husband. So that's another inference that can be drawn from that testimony, that of course she understood that this was a loan. And in fact, she later asked Vishmangal to repay Bharat $550,000. Why would she make that offer if she thought she was not part of the deal?
Well,
all of these conversations, Mr. Scone, I apologize, Judge Jago.
No, go ahead, Judge Harris.
These conversations you're talking about all deal with her promise to repay Bharat.
To repay Reedy.
There's a pleading issue in here because it doesn't mention Reedy anywhere. I mean, the plaintiff incorporates 15 factual allegations, paragraphs 5 through 19, doesn't mention Reedy one time, doesn't say the word plaintiff one time. Every conversation is if they happen, between Daksha and Bharat. Where do you even allege that she knew Bharat acted on behalf of this LLC, or that she owed money to an LLC?
Well, Judge, I mean, the payment was made from the LLC. And I think it would be just a common sense argument that Reedy had to be speaking through someone.
Common sense argument get you past summary judgment?
I'm sorry,
Judge? Some factual allegations here. How would she know that this money came from an LLC? You never allege it. She never talks about the LLC. As far as she knew, it was her cousin's husband who loaned them some money. And there's nothing in here that says that she knew Reedy was ever involved with anything. She never had a promise to pay Reedy, never agreed to pay Reedy, never agreed that Reedy loaned her money. Why isn't Bharat the plaintiff in this case?
Well, because the loan was made from Reedy, sir. And the initial check that was then returned was made out from Reedy. So the borrower certainly knew where the check was coming from.
Well, it didn't go to Daksha. The check was made out to her husband, her late husband. And he's the one that asked Bharat to wire the money.
Yeah, that's correct, Judge. But I don't think it would have been, I don't think Bharat on behalf of Reedy would have made the check out to both parties. The agreement was that they asked for the loan in order to purchase the Lantern Motel. That's clear from the record that those conversations.
Why wouldn't the check have been made to both parties if they had both assented to this purported oral agreement. I mean, wouldn't that just make common sense? You were just saying common sense. Wouldn't that make common sense that the check would be made payable to both? And we don't have any evidence of anything. Certainly, as Judge Harris rightly points out from Reedy, but we don't see anything in writing to Daksha anywhere.
Yeah, Judge, I mean, again, I would say at summary judgment, we have inferences that can be drawn that she obviously knew that that Bharat was the managing partner of Reedy. And it's clear that she knew she was part of that agreement and that it was discussed. So I think there's enough in the record that summary judgment was not proper here.
But what do you make of, and Judge Harris's point that was just made, the fact that her name doesn't appear on anything where her former husband, her deceased husband's name does appear? The check, the wire transfer, the purported promissory note that I know he never signed, the ledger, her name is not on any of those things. Doesn't that matter as far as us trying to discern if there was a genuine issue of material fact here?
Well, Judge, again, I would say that, Reedy had to be, somebody had to be acting on behalf of Reedy. And it's clear from the record that the discussions were that Reedy was going to loan them the money. And then in terms of the ledger.
Well, let me stop you. Where is it clear from the record that she knew Reedy was going to loan them the money? Where is it even mentioned in the record, much less clear that Reedy was going to be the lender?
Well, Judge, Reedy,
it's clear from the record. Point to one place in the record where it's clear that Reedy was going to lend her the money or lend them the money, as opposed to Bharat.
Well, again, Judge, we have the affidavits from both Bharat and Tripedi, where they say that this conversation was had, and the parties knew that Bharat was the managing partner for Reedy. The check came from Reedy. They deposited the check and then used the money to purchase the motel.
Where does it say, though, that Daksha knew that he was the managing partner and this was being made to her on behalf of Reedy? Where does it say that in the record?
Judge, I don't have a record site for you, but I'd be happy to on rebuttal to find that record site.
And I appreciate your candor, Mr. Scavone. Do you believe it's in the record somewhere, or are you just going to scour the record and hope to find it? I'm just trying to understand your response.
No, sir. I believe there are statements to that effect in the affidavits, and that's what I would like to check.
Well, wouldn't that need to come from her?
I'm sorry, wouldn't.
The fact that this was coming from Reedy, I mean, wouldn't she be the one that needed to appreciate that, to have a meeting of the minds as to Reedy? Wouldn't that need to come from Daksha?
Well, again, Judge, I'm just not sure that would be the case, because Reedy had to be acting on behalf of someone. So, that someone in this case was Bharat. It's not as though Reedy could have made a promise to Daksha. That would be impossible. It'd have to come from someone who controlled Reedy Financial, and that was Bharat.
Well, and I appreciate the argument, but back to Judge Harris's point, if she just assumed it was Bharat, even assuming it occurred, it doesn't strike me as that's a good enough thing as to their agreement, their meeting of the minds as to this oral contract, because this has been pleaded as a claim by Reedy, not by Bharat. Wouldn't she need to understand this money, this agreement, this assent, this the actual terms of this involved her and Reedy as opposed to her and Bharat?
Well, Judge, I think from her own testimony and from the affidavits, she made promises to repay the loan. So she knew, or an inference can be drawn that she knew the loan had to be repaid. if the loan had come from Reedy, I'm not sure why someone would have made a check out directly to Barat. In
Mr.
repaying the loan, they would,
Scavone?
yes, sir.
Just going, what was the maturity date on the loan?
So initially there was no specific date provided. It was going to be repaid upon the sale of Raju and Daksha's home in New Jersey. That was the initial agreement.
So nowhere in the record is there an actual date that's a maturity date or a requirement that they sell the home within a specific period of time. Is that correct?
That's correct, Judge. I mean, we were dealing here with, I'm sorry.
Okay. And the other question I have is, I believe there was a history of at least, was it maybe a period of 5 years, I think, where it was just interest payments only on the loan. Where is the payment schedule that gives you the, why were they even making interest payments? Where was that written in or understood between the parties as far as how those payments were going to go?
Judge, there's record testimony from Barat in his deposition where he explained that at some point in the intervening time between 2004 and 2009, when he was asking whether the loan would be repaid, initially Raju, Daksha's late husband, suggested that Reedy place a lien on the motel. And then in subsequent communications, Daksha, according to the testimony, said that she had objected to the lien being placed on the motel. And so Barat, Reedy did not place the lien. And apparently because the loan had not been repaid, it was agreed that that Raju and Daksha would make interest-only payments because it had been so long. Initially, I don't want to say there was a date of maturity, but there was some conversation when the loan was accepted that, it would be repaid in a few months. They didn't expect it to be very long for them to sell the house in New Jersey. But ultimately, when the loan went for years not being repaid, that's when the interest-only payments kicked in.
I know you're into your rebuttal time, but let me ask you this question, Mr. Scavone.
Yes, sir.
On the unjust enrichment count,
Yes, sir.
why would the statute of limitations start on the day they sold the motel? Why wouldn't the enrichment have occurred on the date of the loan or the date they purchased the motel? But you seem to be saying that it starts on the date they sold the motel and she received the 1.2 million.
Correct, Judge. Yeah.
Why? The enrichment was the amount of the loan that you said she didn't pay back. It's not the profit that she got from that loan.
I would disagree, Judge, that there's no unjust enrichment when she purchases the motel. The unjust enrichment comes when she sells the motel for $1.2 million. And
It
then
doesn't come from failing to repay the loan. That's not the unjust enrichment, receiving a loan and not paying it back.
no, because according to the case law that we cited in our brief, the unjust enrichment is triggered. The statute is triggered when the unjust compensation is received. And in this case, that would have been when she sold the motel. That's when she received the money that should have gone to repaying Reedy.
So if she still owned the motel today, she could not be sued for unjust enrichment?
That's
That's your
correct, Judge.
argument?
We wouldn't have had, I'm sorry?
That's your argument?
Yes, sir. I mean, we would not have a claim if she didn't sell the motel and pocket the money. I mean, that, the triggering point was when she sold the motel.
Mr. Scavone, you're into your rebuttal time. I'm assuming you want to reserve or keep going.
Oh, no, Judge, I'd like to reserve the remaining time for rebuttal, and I appreciate it.
Okay. Ms. Edwards, you may proceed.
Good morning, everyone, and may it please the court. My name is Ashleigh Edwards, and along with Kristen Fiore, Christian George, and our co-counsel, Jay Thacker, we're counsel for appellee Ms. Daksha Ben Patel. And since this is a review of a final summary judgment order, the standard of review is de novo. And many of the individuals involved in this case have the same last name, Patel. So I wouldn't usually do it, but to ensure a clean record, I will be addressing the parties by their first names. The appellee asked the court to confirm the trial court's order for 4 reasons. First, Reedy Financial's claim for breach of contract is barred by the statute of limitations, which expired in 2013 and was not restarted by third-party communications and was not supported by evidence of a valid contract. Second, Daksha did not have a fiduciary duty to Reedy Financial pursuant to a familial relationship with Trupti and Bharat Patel. Third, Reedy Financial's claim of fraud was not actionable when its allegations were predicated on a promise to act in the future. And then fourth and finally, Reedy Financial's claim for unjust enrichment is barred by the statute of limitations, which again expired in 2013 and was not supported by evidence of a benefit conferred on Daksha by Reedy Financial. I know many of the questions to appellant focused on the breach of contract claim and unjust enrichment claim, so I will start there. So turning to the breach of contract claim, appellee seeks this court to affirm the trial court's ruling, as the trial court rightly noted and granted summary judgment. Now, as each of you judges in a variety of questions have recognized, this was an oral agreement that occurred. And from appellee's perspective, it was an oral agreement between Bharat Patel and Raju Patel. There's no written contract. All of the writings relate to the agreement are only in Raju's name. So Judge Harris, you and Judge Jay both mentioned that, we have even the deed to the property. There was a draft promissory note, a ledger. None of those documents have Daksha's name in it. And so the trial court rightly applied the 4-year statute of limitations to the breach of the contract claim. Now, there are third-party communications that we've addressed a little bit tangentially this morning. An appellant argues that some of these third-party communications restarted the statute of limitations. Appellee disagrees with that. At no time did Daksha agree to pay an amount to Reedy Financial or even understand, to Judge Jay's point, understand that her husband's, these were business arrangements, this was a contract, or even the essential terms of any oral agreement that may have been in place between Raju and Reedy Financial.
Ms. Edwards, does it matter on behalf of your client whether or not she understood this oral contract she was entering into? Is that part of the calculus for us?
It is, yes, Judge Jay. That is part of the calculus. I mean, in order to have a valid contract, as you mentioned, you have to have an offer, acceptance, consideration, and a mutual assent to the terms. And one of the cases that we cited in our briefs was King versus Bray, which is a Florida 5th DCA case from 2004. And in that case, the court found that a contract was unenforceable because the parties never reached a meeting of the minds regarding an essential term of the agreement. And so here, if the testimony that does exist is Bharat Patel saying he's not even sure that Ms. Patel or Daksha understood the essential terms. So without Ms. Patel or Daksha understanding of the terms, there could not be a meeting of the minds to create or support a valid contract.
Is there any evidence in this record, and you heard me ask Mr. Scavone this, that Reedy had an agreement with Daksha related to this motel, and the amount of the loan? Is there anything in this record as to the LLC and Daksha?
No, Judge Jay, from the appellee's perspective, there is no credible evidence that supports that Daksha was a part of this agreement. As I've mentioned, many of the documents that do exist supporting the oral contract, none of them have Daksha's name. Much of the testimony in even Bharat's deposition said that he didn't even speak to her after Raju passed away, her late husband, in 2013. So Bharat even agrees that he didn't have communications with her, even in his individual capacity. He doesn't discern between his individual capacity or his capacity as a corporate representative for Reedy. And I think that that's an important portion of this argument as well, is that a part of appellant's burden was to ensure that Reedy Financial, as the company, was the party that was purportedly contracting with Daksha. And in the record, there's no evidence showing that Reedy Financial or Bharat in his capacity as corporate representative, communicated with Ms. Patel. And much of these third-party communications, which we contest occurred, much of those communications were with individuals that were a part of Daksha's family. So Trupti Patel is her cousin. Hiren Patel is her son. So many of those communications were not within their capacity or on behalf of Reedy Financial. At least there's no evidence in the record of that. And so from the appellee's standpoint, there was no evidence to support that a breach of contract or even a contract existed between Reedy Financial and Ms. Patel. And because of that, the trial court rightly granted summary judgment on that point. And I do want to turn to unjust enrichment, as the court raised some questions on that as well. That was one of the counts in the complaint. And there were two. There was a statute of limitations argument that the trial court granted summary judgment on, as well as granted unjust enrichment or summary judgment on unjust enrichment on the merits. So from the statute of limitations standpoint, Judge Harris, as it relates to your question, from the appellee's perspective, the trial court rightly applied the 4-year statute of limitations, which should have expired somewhere around 2013. Assuming that Daksha was even a part of this oral contract, which we do not believe there's any record evidence on that. An appellant argues, as we heard, that the statute of limitations on an unjust enrichment claim does not begin until the occurrence of the event that created the uncompensated benefit in the defendant. And appellee agrees with that that's a proposition of law, of course, but agrees exactly when that happened according to the facts of this case. After Raju passed in 2013, the property on which the motel sat was transferred to Daksha through a probate proceeding, so not directly from Reedy Financial, before the order of discharge would have been happened on or about July 1st, 2014. And even if that, so even when Daksha received the property itself that the $850,000 used to purchase, even if that was used as the moment in time when the benefit was conferred, the statute of limitations would have expired in 2018 at the latest, which was prior to the initiation of this lawsuit, which happened in February.
Did Reedy or Bharat ever file anything at all in the probate action?
No, Your Honor. There is testimony that Bharat knew that Raju passed away immediately upon his death. There's no record evidence, and in fact, there is record evidence that Bharat agrees that nothing was filed in the probate action. So the record evidence actually supports that Bharat knew of Raju's passing, did not file anything in the probate estate, and to that point, Judge Harris, Bharat and Reedy Financial didn't file a lawsuit against Raju when the payments were the interest-only payments ended in 2009. Didn't file it in the probate estate. There was no lien that was filed until the filing of this lawsuit in 2019, which was well past the statute of limitations. And so unless this court has any...
obviously here we're talking about, and I believe everybody agrees, an oral contract, an oral breach of contract. So this is not a written breach, a breach of contract based upon a written agreement. And we're also talking about a motion for summary judgment. Should there be any pause in the thought process when you're considering the breach of an oral contract in granting a motion for summary judgment? Because it's important to understand the intent of the parties when you do not have a written document in front of you. And should that be a heightened level, or should there be more leeway given to the plaintiff in this case to potentially get that issue in front of a jury to have the jury determine whether or not there was an understanding from your client as far as the existence of the contract and whether or not there was any joint and several liability for that repayment? Or in your mind, is it, nope, there's nothing here, grant the motion for summary judgment, and the judge makes the determination as to whether or not there was intent?
Thank you, Judge Wallace. And for that question, the trial court, of course, should consider all of the evidence before it, whether it's an oral contract, whether it's a written contract. Now, if the parties, of course, the party's intent, there was discovery in this case, a lot of discovery in this case, where there was depositions of each of the parties, of each of the third parties. In fact, there was a deposition outside of the discovery period to ensure that all of the evidence for intent related to an oral agreement was considered. And the trial court did give some leeway in granting additional time to appellant at the trial court level before a motion for summary judgment was even heard. So we originally continued the motion for summary judgment date. And when looking at the current summary judgment standard that's before the court, that is a relatively new standard from May 2021, all of the evidence that's before the court, it's really only, in Florida, the law is clear that the party opposing a motion for summary judgment is entitled to the benefit only of reasonable inferences that may be drawn in its favor. And so, in other words, a trial court, or our trial court, had an obligation to resolve all those reasonable inferences in favor of Reedy Financial, but not inferences based on speculation or not supported by credible evidence. And so inferences based on speculation are not considered reasonable and are not sufficient to defeat summary judgment. And so here in this case, the credible evidence before the trial court as it relates to the breach of oral agreement supported granting a motion for summary judgment. And so unless the court has any additional questions, I will rely on appellee's brief and request that the court affirm the trial court's findings in its entirety. Thank you.
You, Mr. Scavone, you may proceed.
Sorry, Judge, I was having a little bit of an issue with the mute button. Thank you. To answer the court's question about the record evidence that the loan was from Reedy, at page 588, which is Barat's affidavit, he attested to the fact that he, on behalf of Reedy, loaned both Raju and Daksha the money to purchase the motel. And then in subsequent parts of that affidavit, he talks about they discussed the loan over dinner, and there's also deposition testimony that they all had this conversation about the loan and what it was for. So I think that statement, with the reasonable inferences that can be drawn from the fact that this discussion was about the loan, is enough to at least draw the inference that Reedy, or that Daksha, I'm sorry, knew that this was a loan from Reedy. I want to just quickly address some of the points that were raised by Ms. Edwards. First of all, the crux of this issue is that the trial court didn't view the evidence in the light most favorable to Reedy. What the trial court did was it essentially weighed the evidence here. And under the summary judgment standard, the only time a judge can weigh the evidence is if the record is so blatantly contradicted by the litigant's versions of events that, the court just can't believe what that party is saying. And that's not the case here. In fact, the court 14 times said that there was either no evidence to support Reedy's claims, or that it was undisputed evidence that Reedy did not have a claim. And I would direct the court's attention to the initial brief at 18 to 21, where we lay out in bullet points all of the instances in which the trial court just completely ignored testimony on behalf of presented by Reedy. Judge, I see the light is flashing. Yeah,
I'll give you 2 minutes because of the questions
that.
at the end of your time. So go ahead.
Thank you, sir. So, and essentially what the trial court did here was viewed all the evidence in the light most favorable to Daksha. Ms. Edwards also mentioned that, the judge considered the credible evidence. Well, the credibility of the evidence is not an issue at summary judgment. So just on the facts alone, the trial court really didn't really acknowledge any of the facts to the contrary. In fact, if you look at the bullet points I referenced to, you'll see that most of the factual findings were made based on Daksha's deposition, to the exclusion of the affidavits and depositions from Reed. The second point I wanted to bring up is the idea that this was a future promise. We've cited case law for the proposition that future promises are actionable under fraud if there's an intent that the party didn't have an intention to repay the debt. There are several inferences in this case and facts in this case that can be drawn that shows that she, in fact, never had an intention to repay the debt. She made repeated promises and didn't repay the loan. She had testified that even before once the property was conveyed to her for $100, she continued to make promises that she was going to repay the loan and never did. So that certainly supports an inference that she never intended to repay the loan. And in fact, the intent of her intent is actually something that should not be decided at summary judgment, because that issue is a factual issue, whether or not she intended to or didn't intend to repay the loan. So in concluding, Judge, based on a series of false promises, Daksha avoided making good on her obligation, and she profited to the tune of $1.2 million. Her conduct here was unjust, and the equities are certainly on the side of Reedy in this case. The trial court short-circuited the entire process by ignoring Reedy's evidence and viewing the evidence in the light most favorable to Daksha. And the appellant asked this court to reverse. Thank you for your time and your consideration.
Thank you, counsel. Interesting case, very well argued. And at this time, we will be in recess. Have a great day.
Thank you, Judge.
Thank you very much. You as well.